Hello, this is Matt on the Moon Lambo channel. If you ever think that the SEC attorneys couldn't possibly sink any lower, couldn't become any more ridiculous, it couldn't become any more irrational, they couldn't possibly have arguments that are less logical, just know that you are wrong for thinking that. You know what they're doing now? The SEC is trying to get John DEATON and the over 68,000 XRP holders that he represents. He's trying to, the SEC attorneys, they're trying to get them kicked out of the case. I kid you not. And you know why? Because reasons. It's always because reasons, folks. Completely ridiculous here. So, look, and that's not the only thing. There's just multiple gigantic things in here, and the community's understandably been speaking about this very in-depth. Social media, specifically on Twitter. But you know another thing that's in here, and I'll just tell you this at the outset before we get into the nuts and bolts of this. There's a footnote that was stated where the SEC states that effectively, and I'm just paraphrasing here, I'll get to the exact wording, but they're not going after XRP holders. No, we're not in any danger. Now, of course, if you've been following this case, you know that the SEC holds contradictory positions on that. If you outright ask them, oh, no, we're not going after XRP holders, but then they make the assertion that XRP, by the nature of it existing, does represent a security. Because of reasons. Again, it's always because of reasons. Also, we learned that the SEC expert witness who claims to know why XRP holders bought XRP, that'd be Patrick Doody, my friends, he did not interview one single XRP holder. And there's a transcript without his name attached to it, but if you put the pieces together, I don't know who else it could be. So it seems like a virtual certainty it's Patrick Doody who acknowledged publicly that didn't bother speaking to a single XRP holder, but came to conclusions about why they purchased. This is going to be a fun one, folks. It's going to be one hell of a barn burner. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so shout out and credit to XRP community member and attorney James K. Filan, who broke this story, and he did so with this tweet. He wrote the following. Hashtag XRP community SEC versus Ripple hashtag XRP. Breaking. The SEC, in a heavily redacted letter alleging threats against an expert, asks Judge Torres to revoke Amici status granted to XRP holders and to bar John DEATON from any further participation in the case. And so you may recall that there were, allegedly at least, threats made against an SEC expert witness named Patrick Doody, who has a very hilarious last name, obviously. We can all agree on that, I'm sure. And we haven't seen the evidence. We still haven't seen the evidence. That's the assertion that the SEC is making. To some degree, Judge Torres somewhat sided with him. I don't know if it was out of an abundance of caution. I can't speak to that, honestly. If there are any actual serious, legit claims, any person with any semblance of rationality and a heart would say, yeah, of course, that's inappropriate. There's no way that you could possibly support, threats made against anyone. That's not remotely reasonable. I haven't seen the specifics, and I don't trust the SEC. So, what else what other conclusion can I come to? And so, the SEC here asking Judge Torres to revoke Amici status. So that's the status that Judge Torres approved. Saying, yes, DEATON, you can participate in the case as a party that has a vested interest, obviously, and the outcome of this case, including the XRP holders, over 68,000 XRP holders that it represents. And SEC says, no, you should not be in this. So I'm gonna go through their parts. You can hear this. I got some dead trees up in my little Moon Lambo fingers here, and I highlighted parts that I found most interest and made some notes. And I will say this, given that this was breaking news from Attorney Filan, I opened up this document, and it's actually 94 pages, but that's because there's exhibits, which admittedly I haven't gone through all those, but I did read the entire primary document, which is only 5 pages. And I noticed immediately that it was dated June 7th of this year. I was like, wait a minute, breaking news, June 7th. Well, I put the pieces together very quickly, obviously, in about 1.5 seconds. This has to do with the allegations, which again, like I said at the outset of the video, I think probably most of you are aware of at this point, where there was the SEC expert witness Patrick Doody, and there were these assertions of threats made against him. So this is the document that the SEC wrote talking about it, but as you can see, and you'll see as I scroll through this more, there's heavy redactions. Crucial pieces of this we don't have access to right now, and perhaps we never will, but I am going to share with you, there's some real gems in here despite that fact. So I'm going to go through this, but first I want to share with you some comments from 3 different attorneys within the XRP community. So, and by the way, so as far as it being June 7th, I did want to mention this too. I don't know why this was just released, but it was just released, so it's still breaking news. But if anybody's wondering, yeah, it's finally out, and I'm glad I can share with you what I shared because there's some very genuinely interesting stuff in here. But attorney Jeremy Hogan had the following to say about this. He wrote, "Imagine you're a second-year law student who just started clerking at the SEC. Exciting! And then you are given the job of scrolling through Twitter and YouTube to look for anything that makes an attorney and 68,000 people look bad so they can be attacked in a pleading. Imagine." Yeah, you just wait till we go through this. This document, it's designed, they're trying to anyway, make attorney John Deaton look bad, but the things that they cited that are intended to make him look bad, the judge already knew about. Like, this is not new information. It's old information, and the judge clearly didn't agree with the SEC. They're still bringing it up, and then they're saying, effectively, "Judge, well, we think you made a bad decision allowing attorney Deaton, so how about you change your decision?" Like, I'm just sitting here thinking, if I'm the judge, like, do I not find that offensive? Do they think I'm stupid? You know? What in the ever-loving... I can only imagine what went through Judge Torres's mind upon reading this and having her judgment questioned yet again from the asshat attorneys at the SEC. And then attorney John Deaton himself responded to what Mr. Hogan wrote there, and he said, "Don't forget that they listen intensely when that attorney is on Charles Payne's show on Fox Business, and also listen in on Link2's Twitter Spaces." They do. The SEC is definitely paying attention to what's happening on social media here. And so they literally have somebody just going through all of this stuff in just a desperate hope that it's somehow going to have a notable impact in the case. And so far, it's not working out so well for him. I'll just tell you that right now. But it's so funny, the idea of what Mr. Hogan said here. You're hired by the SEC, exciting, you started clerking, and then you're just checking out stuff on Twitter and YouTube. That's kind of what it is at this point. And then there was this from attorney Deaton. He said, "Make no mistake about it. I would be one man screaming at the wind without the support of this decentralized community. The SEC has literally become unraveled because never in history have 68,800 people from around the world come together to simply say, 'Stop protecting us.'" It's so true though. And mind you, that's what they say. They're protecting us because we're investors. They're protecting. Well, this is protection. This is the most harmful protection I've ever witnessed in my entire life. Get the hell away from me. And then there was also this in a separate tweet from attorney Deaton. He said, "Thank you to everyone who continues to stand together. Not only do I respect you, I effing love you." And he did censor himself there. And then he said, "The SEC can now add this tweet to the collection of tweets they gave the judge and claim I should also be barred for sorta using profanity." And you'll see as I hop into the specifics here, that's exactly what they did. They took out tweets, they cherry-picked some stuff, took it, put it out of context, and then they've just been hoping that the judge says, "Oh yeah, that's really bad." No, the judge already went through, the judge was aware of this stuff. I don't know what the hell they're thinking. They're just bringing up the same old crap again that already didn't work. What is their malfunction? And then there was this from attorney Fred Rispoli within the XRP community, and he shared the following thoughts. He said, "Still waiting on SEC's filing, but so far, first, Judge Torres is not going to reverse her Amici ruling." So just another way to word that to be clear. He's saying that in his opinion, there's no way that Judge Torres is going to bar John Deaton from participating in this case. He doesn't think that's the case. And then he continues and he says, "SEC's backhanded reconsideration motion denied." Yeah, and I think it's backhanded too, because like I said, they've already brought up all this crap. It's so desperate. It is so they so badly don't want what John Deaton and the 68,000 XRP holders can offer. So the court can make a reasonable decision. They so badly don't want that to be presented that they're going to extreme lengths that are completely disingenuous to silence those who they allegedly are protecting. Well, this is the most perverse protection I've ever seen in my entire damn life, son. Attorney Rispoli continues, and he says, Second, did Ripple team forget what the motion is about? Providing Mr. Duty's report to Amici to participate in Daubert motions, yet Ripple team explicitly took no position on that, though did say it wants Amici in dispositive stage. So what he's talking about right here, you may recall, Attorney DEATON requested permission to respond to the reports that the SEC's expert witnesses will be putting out, which they've already created. We just don't have access to them. Attorney DEATON just wants to be able to respond to that. Of course, the SEC doesn't want them to be able to respond to that. And so there are these Daubert motions also, and as a reminder, a Daubert motion is something that you can file to make a claim that, one of two things. An expert witness either isn't actually an expert, or the methodology used in coming to a conclusion is flawed methodology. So you make those claims, it's called a Daubert motion, and you're basically just trying to get those experts thrown the hell out of the case. That's effectively it. And so what he's stating here in addition to that is that Ripple actually didn't really speak to anyone within the XRP community. I mean, pretty much, like, they didn't depose anybody within the XRP community about why they're purchasing XRP or anything like that. And so he's saying, sounds a little strange, right? Isn't that a little bit peculiar, given especially what the topic is about right here? And I have a couple thoughts on that, which I'll circle back to, but I just want to go through what Attorney Rispoli has to say. And then he said, weird. Third, nice job on the first two arguments. Tell court defendants threatened as well, and remind court of multi-billion-dollar pain inflicted on everyday XRP holders. I do like that part. Then he says, SEC made a mistake in not designating report confidential. I would have to imagine Judge Torres thinking to herself, just like the mistake you made when you first said Hinman's speech was personal. Yeah, think about that. Yeah, the speech was just personal, but then it's also part of the SEC's official position, or at least the Hinman division. He was running the corporate finance, or maybe it's corporation finance, whatever it's labeled. So that's what he was running. So that's the official position. It wasn't just Hinman's position after that, depending on whatever suited their needs at the time. And then he says, also, fourth, if SEC brief accuses Ripple team of lying and disclosing to Attorney DEATON, it better prove it, or Judge Torres will be pissed about such a serious accusation. So I'll pause to note what he's stating there, and it is cited in this brief from the SEC, which I'm going to run through with you in just a second here. They did note that Attorney DEATON had some information that apparently they don't know how he had it at that particular point. And so if they're going to accuse Ripple of lying, you better freaking prove it. And if I'm Judge Torres, I'm sitting here thinking, if you're going to make wild assertions, those are serious assertions and accusations, you better prove it. If you're saying Ripple's lying. And then he says, bottom line prediction. Amici participates, but maybe not in Daubert round, but does get access to some discovery provided counsel signs a protective order. And then he said, P.S. He came back a little bit later and added to his thread. He said, can't believe I forgot to add this. Brief confirms SEC did not have its expert interview one single XRP holder. That is just lazy and undisciplined. I could go into detail on how bad SEC messed up here, but I'm pretty sure it is monitoring my account, so no freebies. So he thinks that and he may be right. This is not wacky to think this in the least. We already know that they're monitoring social media, so of course. Attorney Rispoli here, he says he thinks the SEC is monitoring their account. Well, given that he did sue Jay Clayton and Bill Hinman recently, before shelving that to come, he's going to come back at a later date. I think it's pretty reasonable to suspect they may be watching, right? So this is true, though. In fact, I have the transcript pulled up, and this is what I was referencing a little bit earlier in the video. I'll make this full screen for you. And so we are making an assumption technically, but if you just, through context, put the pieces together, you can kind of figure out, okay, this has to be Patrick Duty, right? And so there was a question here, and this is under deposition. Did you try to find any XRP purchasers to ask them? So let's pause. So that's the question, and to ask them what, obviously. Well, why'd you purchase XRP? Because the guy claims to know. And so here was the answer from the individual who is technically unnamed, but who I believe is Patrick Duty. And this individual said, I did not interview specific XRP purchasers or attempt to validate whether anybody did, make a specific purchase and what their knowledge of Ripple was at that moment that they made that purchase. Well, that's going to be kind of rough, because that's an expert witness who didn't bother to speak to them, but yet is going to make all these assertions. And then on the flip side, you've got Attorney DEATON, who has thousands of sworn statements from XRP holders on why they purchased. And most people, when they purchased XRP for the first time, hadn't even heard of Ripple. And he has proof of this. He has cited that he has proof of this. And then there's this from Attorney Rispoli. He says on, let's see, of the SEC's brief filed in Southern District, New York today, you now have permission and or fair notice to relist XRP. Waves of money would follow. Timidity and fear are stopping you, or are they? And you'll see what I'm going to share with you some more on that idea in just a second here. And then there was this. Actually, I think this is probably a good point where I can actually jump into the actual specifics and then circle back around to what Attorney DEATON had to say in this tweet that's on your screen right now. So let me go back to the actual document here. So this is it. This is, again, you can see at the bottom, it goes to 94 pages. I only read the first 5 because that's the actual legal brief. The rest is just exhibits, and there's no way I'm getting through that today. Definitely not today. And so let me share with you key parts that I highlighted, and I did take a couple notes along the way so that I wouldn't forget what I wanted to say here. The legal stuff, honestly, it can fry your brain. Try doing this. Like, if you're not an attorney and then remembering what legal terms mean and then keeping your thoughts straight, like, I like to do stuff on the fly, like all of my videos are, unless I cite otherwise, and that's an example here. It's just like, I just want to make sure I don't forget something. Anyway, reads as follows. Dear Judge Torres, Plaintiff Securities and Exchange Commission respectfully opposes 6 XRP investors, so those would be the movements, that, Attorney DEATON representing them, that's movements, motion to file an amicus brief regarding the opinions of one of the SEC's experts. And so again, that has to be Patrick Doody who they're referencing there. Then you scroll a little bit lower right to about here. Right, can I not highlight this? I can't highlight this. Okay, well, never mind. Well, right where I'm circling. So check out this. The SEC asshat attorneys wrote the following. DEATON, a lawyer admitted to practice in Rhode Island, has repeatedly tried to insert himself into this litigation. So I just wanted to say, on that point, this sentence shows the extreme level of contempt that they have for Attorney DEATON. They're not even trying to be reasonable at all with the way they're approaching this with the judge. Seeking to insert himself into the litigation. Well, you attacked him. He is an XRP holder, and like he's one of the people. I am too. It's like, you're going after all of us. Like, we deserve to have a say in this. And you know what? The judge agrees that he should be allowed to participate, right? So you can word it like you want, and you can be, pout like a little 5-year-old, but he deserves to be here representing over 68,000 XRP holders. You can word it like that because it makes it sound bad, but man, it just makes you look bad, SEC attorneys. It doesn't do anything for you here. And then they also wrote, a little bit later in the paragraph, as demonstrated by these filings in DEATON's Twitter feed and public statements, movements are investors in XRP who believe that this case has deprived them of investment profits in XRP. Okay, not only that, though. You see, you know what we also believe, in part? We also believe the SEC is destroying XRP utility. The XRP utility that you claim doesn't exist, you're destroying it, because if people can't even buy XRP, they can't freaking use it. And so think about how liquidity in the United States has dried up. You've destroyed on-demand liquidity markets, which are designed to help some of the poorest people on the planet who most need to save this money. I'm disgusted by it, frankly. But to state something like that is offensive, but almost everything you say, SEC asshat attorneys, almost everything you say is offensive. Because you know that you're lying, we know you're lying, and we're also supposed to pretend like you're actually being reasonable adults. No! Screw that. And then here you can see, man, this thing's heavily redacted. I would love to see what's under those black bars. But take a look at this, and this is where they're trying to make Attorney DEATON look bad. But this is information that had been brought up and was known by Judge Torres when she approved John DEATON to be amici curiae, which just means a friend of the court. So that means, just be clear, that means that's when the judge granted the permission to participate in this case. All of this was known, yet still they're writing about it here, trying to get John DEATON barred because he's so effective. Or else, why would they bother? If they don't think he's effective, why would they bother? And so here you can see, March 12th, 2021, DEATON tweet. There is only one way to deal with a bully. Punch that MF in his face. I'm up at 3 a.m. for a reason. Profanity redacted. See you soon, SEC. Look, a pause to note here, and it's clear, and Judge Torres could easily see through this. John Deaton is not actually supporting violence. It's a way of speaking, right? Who in their life has not done this at one point or another? You know, or have you ever said, "Oh, I could just kill him, just whoever." You know, speaking about some random person on any time. You don't really mean you're going to kill them, do you? Of course not, unless you're an insane person, psychopath. No, he doesn't. He's not actually threatening violence here, and the judge knew that. That's why she was happy to have him in the case. She thinks it's worthwhile. But the SEC's still putting this garbage out here as if it's going to trick anybody. It's disingenuous. They're not fooling anybody. And then they provided a link to a YouTube video we put out where Deaton stated, quote, "Might have to walk over there and slap the," profanity redacted, "out of former SEC Chair Jay Clayton." Which, by the way, I thought was hysterical. But he's not literally encouraging violence. It is so clear. It was in a video that was clearly satire. Couldn't have been more obvious. Jesus freaking Christ, man. All right, now let me get down to page 3. Take a look at this. Yeah, so right under the second black bar where I'm circling right here, reads as follows. Movements do not propose briefing on legal issues. Instead, they wish to present argument based on 3,252 form affidavits from XRP holders attesting to certain facts. So I'll just pause to note there. Attorney Deaton, and he had publicly stated that he had this information, he's got over 3,000 sworn statements from XRP holders attesting to certain specifics about why they're holding XRP, and I don't know exactly what else would be in there. That information is not publicly available, and that's fine. But he acquired this information. He sought it, and he acquired it, and so that's what was being mentioned here by the SEC. And then they continue. The court has already rejected Movement's attempt to offer evidence or present witnesses. As the court noted, there were no legal or practical constraints preventing defendants from obtaining the relevant facts through discovery. So they're talking about Ripple there. They're saying Ripple could have discovered relevant information purely through discovery. Discovered it through the discovery process, right? And then they say, for instance, by deposing movements. So stating there, the movements, so that'd be those who John Deaton represents, including John Deaton, they didn't depose them. Ripple chose not to. That's what they're citing there. I just want to make sure, because the way this legal stuff is worded, I mean, if you're a lawyer, it's a no-brainer. Like, yeah, of course I understand that. But for somebody that's not accustomed to using specific language like this, which is not the way humans talk in everyday life, I get this is the English language, but it might as well not be sometimes. You know what I mean? So that's why I always try and break this down to the best of my ability here, even though I just... It makes me wish I had a legal background. It'd be a lot easier then. And then they also say, defendants who were entitled to 30 depositions noticed just 2 and chose not to depose movements or any XRP investors. So that is interesting. So I wanted to say a couple things on this. Because look, like, why didn't Ripple seek sworn testimony from any XRP holders? I mean, at some point they found out, I don't know when, but they found out that Attorney Deaton did seek all of that type of information from thousands of people, no less, actually. So, I mean, is it the case that they were hoping that it would be presented in the case by Deaton and perhaps it would be perceived as more powerful if so? Well, I don't know. All I can do is speculate on that, but it does make you wonder here. I mean, if the SEC's right, and we'll see what the judge rules on, because I don't know how this is going to shake out. The SEC's claim is that this is outside of the role of what Deaton is supposed to be presenting. And if that's true, I mean, let Judge Torres make her legal determination on that. But I'm sitting here thinking, like, just as a layperson, like, this sure as hell sounds like why we're here, explaining why we have a vested interest as XRP holders when we have separate motivating factors separate from Ripple, the company. Doesn't it seem like a perfect thing to have included here? Just thinking from a logical perspective, not from purely a legal perspective, because I'm no legal background. I don't know what the legal standards are for crap like this. But just from a logical perspective, doesn't it seem like something that would be perfectly reasonable to have in here and considered? Well, I mean, I sure as hell think so. And then a little bit further on, they wrote the following. Permitting Deaton to offer these affidavits in contravention of the court's prior order would be prejudicial, delay the resolution of the case, and constitute an in-run around court-imposed limitations on the parties, including discovery restrictions and the rules of evidence. So setting aside, obviously, the fact that they're arguing that this is outside the scope of what amici curiae, so DEATON and the 68,000 XRP holders are supposed to be providing in this case. Aside from that, did you catch the part where the SEC is now complaining about a potential delay in the resolution of the case? Are you freaking kidding me? How many delays did we have because of these pricks at the SEC? How many delays? And then they have the audacity to sit here talking like DEATON getting to respond to these stupid expert witnesses, him respond, all this. That is an unreasonable delay for the case? Are you freaking kidding me? These people are the worst. If you're the judge, there's no way you fall for this. There's no way you think that they believe the crap that they're just arguing stuff because of reasons. That's what they're doing. That's why I keep saying because reasons, because there isn't logic behind it. These people are the freaking worst. And then a little bit, can you tell it's grinding my gears, folks. It's grinding my gears. I think it's simultaneously burning my biscuits. I don't like it. I don't like my biscuits getting ruined. A little bit lower on your page here, where I'm circling here, they wrote the following. Fourth, movements proposed brief would merely duplicate defendants' efforts. Oh, freaking God. Movements and Ripple's common interest dates to years before the filing of this case. So there you go. Think about this. Look, no, as SEC acknowledged, DEATON has thousands of affidavits, that's sworn testimony from XRP holders, which Ripple doesn't have. That's different information. So what the hell are they talking about? Duplicate defendants' points of view? No, Ripple doesn't have that. You just said that. I just read it. It's on your screen right now. Did you forget? Did 2 or 3 different people write this separate, and then you just stapled it together without reading it in one passing motion? It's unbelievable what these people are arguing here. And also, the court has acknowledged the usefulness of DEATON and XRP holders and having their perspective as part of the case. So to state that it's all the same, you're basically screaming at the judge, you're wrong. Because the judge already said, no, this is useful. This will be helpful to the case. And they're saying, oh, no, it's just the same thing as what Ripple's arguing. Well, no, the judge already said no. Do you think you're even doing yourself any favors writing this, you freaking idiots? What a bunch of idiot sticks. Hashtag idiot sticks, man. Oh, man, now it's steaming my vegetables. Now I can feel them vegetables getting all steamed up in this bitch. I go a little bit lower here. Under the Section 3 conclusion. Oh, take a look at this. And yes, it does get better and better and better and better. Under conclusion, they wrote the following. And this is like where we're starting to really come full circle from where I started this video. Because this is about barring attorney John DEATON. They wrote the following. In addition, the motion seeks to brief factual rather than legal issues, to do so on a non-dispositive motion, and to make arguments that defendants are capable of making. Movement's motion should be denied, and pursuant to the court's broad discretion to permit or deny the appearance of amici, then this is it, listen up, DEATON should be barred from making additional filings or otherwise participating in this case. What? The SEC may seek further relief from the court in light of DEATON's and his followers' recent conduct. Bar DEATON? Are you kidding me? The SEC again here. This is another part where, in a big way, the SEC is telling Judge Torres that she made a mistake by allowing DEATON and XRP holders to have any sort of presence in the case. Again, imagine you're Judge Torres. How do you take this? Do you take this well? The decision's already been made. There's not new information here. Unbelievable, these people. Now take a look at this at the bottom, because it gets a little bit more ridiculous, and people understand, I understand why. Within our community, we're talking about this. And based on what I'm about to read you, it's footnote number 2 on your screen there. People were saying, oh, well, if the SEC is saying this, then it's time for exchanges to relist XRP. And I even tweeted out earlier, relist XRP. Or maybe it was hashtag relist XRP, just because they should. But here's the thing, and I kind of said this a little bit earlier in the video too. It's not crazy to think, yeah, see? Based on what's on your screen now, which I'm about to read, they should relist XRP. The problem is, they've said, they've made other written statements that are completely at odds against this. It's like, what conclusion do you come to there? You know? It's like, ask me if I want pizza. And then I say yes. And then you ask me again, do you want pizza? And I say no. Well, which is it? Like, it doesn't make any damn sense. So check this out. Footnote number 2. Movements mischaracterize the SEC's claims as claims against XRP holders in the secondary market. But while Securities Act Section 5 requires Ripple as the issuer of XRP to register its offers and sales for the benefit of actual or potential investors, Section 4 could exempt investors in the market from registration. The SEC's claims are for Ripple's offerings and those by its affiliate, not purchases and sales by investors in the market. So you can understand why, upon reading that, people in the market are just like, yeah, so relist XRP. From a legal perspective, it's not clear, which is why, as a result of that, you will not see any exchanges relist XRP, not until this whole thing's fully adjudicated. Because what are they actually arguing? Do you remember, where do I have it? Somewhere here. Yeah, so this is, John DEATON shared this many times. I probably don't even need to read this. If you want to pause and read it, it's on your screen. I've shared this so many times, though. This is where the SEC is arguing, well, I guess I could read the first part. Movements claim they must intervene to convince the court that XRP is not per se a security. And so that's about a little bit, not quite halfway through what's on your screen there. But what do they go on to state here? I mean, because this is why it's so mind-boggling. I've covered this so many times. I'm honestly sick of explaining it, like even describing it. But they are arguing that XRP is a security per se. The SEC has also argued that XRP is the representation of an investment contract, which means a security. That's what's on your screen right here. And again, I don't feel like reading this again. I've read this many times on my channel. But they're saying that XRP, even say traded in the secondary markets, it represents that investment contract. So they're saying the opposite thing. It's on your screen, folks. What the hell do you even do with that information? Well, when they're saying two completely contradictory things, do you think that, Coinbase is going to relist XRP? Because I sure as hell don't think that's going to happen. Now, I'd love to see that as a big old middle finger to the SEC, because really the SEC is just going to come after Coinbase and all the other exchanges next. I think that's highly probable anyway, claiming that they're selling unregistered securities. So it's like you might as well instead of just taking a defensive approach, maybe punch back a little bit. You know what I'm saying, so to speak? Not literally. See, if the SEC heard that, they'd be like, oh my God, Moon Lambo's calling for physical harm against... No, shut your stupid little bitch-ass mouth up. I do not have patience for this at this point. I really do not have patience for this. And so on this point, footnote 2 that I just read, John DEATON's not buying it. And he doesn't think that this will result clearly in exchanges relisting XRP. But check this out. Footnote 2 is legal gibberish and could be called gaslighting. Again, this is from Attorney DEATON. He says, don't take my word for it. If you want to learn all you need to know about Section 5 and the Section 4 exemptions, go to crypto-law.us and read the Telegram decision by Judge Castell. Sounds reasonable to me. John DEATON's right about this. There's no question he's right about this. And the SEC, oh my God, I hate these people. They are the freaking worst. This is how much they don't care about anybody listening to this. This is so unprecedented. 68,000 XRP holders asking to participate in this case. This has never happened in the history of lawsuits having anything to do with the SEC. This is completely unprecedented. So it's understandable to some degree that the SEC, as untalented as they are, they're no talent ass clowns. Of course they don't want DEATON participating because he's on the right side of history and the facts are on his side. It couldn't be more clear. My gears have stopped working. They're so ground up, they're not even working anymore. So I'm going to have to simmer down and, I guess, end this latest Moon Lambo hot jam. But please tell me what you think about all this stuff. I think we're all pretty well on the same page. I'm just sick of it. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.